Greetings from ELP, Economic Laws Practice. I am here to discuss two important changes which has been brought about by this finance bill in the income tax. Under the income tax law, the two provisions which are quite crucial. One, the entire facelift of the faceless assessment under section 144 AB. That is something wherein subsection 1 to subsection 8 has been entirely revamped with new set of subsection 1 to subsection 8. Although more or less the entire mechanism of faceless assessment remain the same, but few takeaways with the changes what we have got. One, which is the most important thing, is the granting of a personal hearing. There was an issue whether the personal hearing need to be necessarily granted in a case of faceless assessment. The issues were there before high courts. Various writ petitions were filed. In one of the writ petition in case of Bharat Aluminium Company Limited, Delhi High Court stated that even though the word may is used, but may shall be read as must or shall, and personal hearing ought to be granted. Wherein it was the contention of the department that no, in granting a personal hearing will mean incorporating a face into the faceless assessment. Now, all such disputes and the differences of opinion have been put to rest, because with this new scheme or the facelifted scheme of faceless assessment makes it very clear the personal hearing is a necessity whenever the taxpayer or the assessee asks for it. This is an important change. There are other changes also in terms of how the entire mechanism would be carried out, but more or less the entire scheme remain as it is. The role of regional faceless assessment center is has been done away with. It's no more there. Everything would be routed through national faceless assessment center. That is one of the important aspect. So and one more important point, that in every case a show cause notice and draft assessment order both would be a necessary requirement to proceed on any matter where there is any proposal to add any income. So this is one important aspect. The another important aspect is the introduction of section 158 AB, which is about reducing the litigation burden at court. It says that if there is any issue in case of any order which has been decided in favor of the SSE, and if that issue is a subject matter of question of law, and if it is pending before any jurisdictional high court or Supreme Court by way of an appeal or special leave petition, then in such a case, a collegium which would comprise of this designated officer may ask the jurisdictional officer not to file an appeal, and they may just wait for the outcome of such pending cases. Such case may be in case of the SSE itself, it may be any other case related to any other SSE. So in by way of doing this, what would happen is that even if there is a favorable order, even if the department has went for an appeal in any other case, but if that is a favorable order for the SSE, this will not get into the courts for the purpose of unnecessarily increasing the burden. So in such cases, within the prescribed time, which is 60 days or 120 days, depending on whether the matter is before Commissioner Appeal or ITAT, there would be an application would be made that yes, they'll be waiting for the outcome of a particular case, and depending on the outcome, they may file an appeal. One important aspect which has been taken care is that in any such case, the SSC's confidence will be taken into consideration unless and until there is a consent from the SSC that yes, the question of law is identical, the jurisdictional officer will not proceed. This is a welcome change because it will not only reduce the burden on court, but also the litigation cost and all the hassles of moving on with a particular litigation wherein already a favorable order exists on a particular given question of law. So these are the two important changes I would suggest in terms of the improving the overall dispute resolution mechanism under income tax. Thank you.